and along with the petition, IA filed for seeking interim maintenance. What is the date of filing the application?
10/3/2020.
On 10/3/2020. Though the magistrate posted the matter for passing orders on IA on 16/11/2021, reserving the case for passing orders on 1/12/2021, but not passing any order on the interim application for granting maintenance. But while the adjourn the matter for recording the evidence by 12/1/2021. ಅದು 22 ಇರಬೇಕನು.
ಹೌದು ಸ್ವಾಮಿ, ಸಾರಿ, ಟೈಪಿಂಗ್ ಎರರ್ ಇದೆ. ಅವ್ರು ಬರ್ದಿದ್ದಾರೆ ಕರೆಕ್ಟ್ ಆಗಿ 22
ಇರ್ಬೇಕು. ಅದು ಅಂದ್ರೆ 12/1 ಅಂತ 1/12 ಆದ್ಮೇಲೆ ಮತ್ತೆ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಇಸ್ ಅಬ್ವಿಯಸ್ಲಿ 22.
ಅವರು ಬರೆಯುವಾಗ ಬೈ ಮಿಸ್ಟೇಕ್
22 ಅಂತಾನೆ ಇದೆ ಆರ್ಡರ್ ಶೀಟ್.
ಅಲ್ಲ, ನೆಕ್ಸ್ಟ್ ಪೇಜ್ 22 12/1/22 ಕರೆಕ್ಟ್ ಆಗಿ ಬರ್ದಿದ್ದಾರೆ ಟೈಪ್ ಕಾಪಿ. ಬಟ್ ಕೈಯಲ್ಲಿ ಬರೆಯುವಾಗ 21 ಬರ್ದ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಟೈಪಿಸ್ಟ್ ಬ್ಲೈಂಡ್ಲಿ ಫಾಲೋಡ್ 21. ಐ ಆಮ್ ಸಾರಿ, ವಾಟ್ ಎವರ್, ಟೈಪಿಂಗ್ ಎರರ್. ಇಟ್ಸ್ 22 madam.
Yes. Civils, the petition, the trial court, without passing the orders on IA and without giving any reason, filing, posting the matter for evidence is not correct. Therefore, it is necessary to issue direction to the magistrate to pass the orders on IA. In accordance with law, accordingly, petition is disposed of. The magistrate. So, ಯಾವ court ಅದು?
Fifth additional Metropolitan Traffic Court. Fifth additional Chief
MMTC 5th Court, Bangalore, to dispose of the IA 1/2020 within 2 months from the date of issue of the copy of the order. Seal is 65/20.
Highly obliged.
Yes, sir. Who is argued?
Pardon, my lord.
ಯಾರು ಕೌನ್ಸಲ್ ಅಂತ ಹೇಳಿದ್ರೆ ಹೂ ಇಸ್ ಆರ್ಗ್ಯೂಡ್ ಅಂತ ಕೇಳಿದೆ. Who was argued?
My colleague has argued, and the other side,
ಅಲ್ಲ, ಯಾರು ಆರ್ಗ್ಯೂ ಮಾಡಿದ್ದು ಯಾರು ಸರ್? Who was argued? I am asking.
Suresh Lokre, senior.
ಅದನ್ನ senior counsel, you should say. That's why I am asking. Suresh, senior counsel, Suresh Lokre.
I thought Lordship recognized me. I'm sorry, madam.
ಅಲ್ಲ, ಈಗ ದೊಡ್ಡದು ಫೋಟೋ ಬಂದ, ಅಲ್ಲಿ ಸ್ಮಾಲ್ ಫೋಟೋ, I couldn't see who is arguing.
Yes, sir.
I remember that this voice,
yes, sir.
But I couldn't see. That's why I asked who argued.
Much obliged.
Yes, sir.
Much obliged.
Anyway, what
correct, my lord. I will say
compounding offense.
Order be made at 1 month, my lord. My request, my lord, 1 month I'll dispose. ಏನು ತೊಂದರೆ ಆಗಿದೆ ಮಕ್ಕಳಿಗೆ ಸ್ಕೂಲ್ಗೆ
1 month ಮಾಡಿ ಅದು ಯಾರದು ಇದರ 1 month from the date of issue of the copy of the order. ಅಲ್ಲ ರೀ, ಅದು ಸೆಟಲ್ಮೆಂಟ್ ಯಾರೋ ಬಂದಿದೆ ಕನ್ನಡ. ಯಾವ್ದು ನಂಬರ್? 32. What is the case?
Live streaming start ಆಗಿದೆ.
Yes, what is the case? Quashing FIR or charge sheet? 498A. Respondent 2 is there? Application filed for compounding? Application is filed for compounding? Who are the petitioners? Accused numbers? The petitioners are accused number 1 to 5. Who filed this petition under section 482 of CRPC for passing the FIR in crime number 170/21 registered by Sira Police District Tumukuru for the offences punishment sections 323, 498, 504, 506, 114, and 34 of IPC, Indian Penal Code, real referred as IPC, and section 3 and 4 of Dowry Prohibition Act.
The affidavit ಇಲ್ಲ ಅಂತ objection ಹಾಕಿದ್ರು.
There are two affidavits filed, sir. Joint affidavit is there. These are two names. Divya Priti is there. During pendency of this petition, the parties have came before this court and filed an application under section 320 of CRPC seeking permission of this court for compounding the offence, consequently caused the FIR. The petitioner 1 to 5 present along with their counsel, and the respondent number 2 also present along with counsel. What is the name of the counsel? Ananda. Ananda. Kumara for Ananda. HG appears for Arva. Madam, to settle the matter, well, what is the settlement around between the parties? Joining together or divorce granted? The advocate, the petitioner submits, matter has been settled between the parties before the matrimonial case in MC number 4080/21 on the file of 5th additional Principal Judge Family Court, Bangalore. And the divorce has been granted by the competent family court, and the parties are now came forward for compounding the offence in view of the settlement around between the parties. So, as per the judgment of the Honorable Supreme Court, Gansing versus State of Punjab, the parties have settled their dispute in the matrimonial case. The court can cause the criminal proceedings. It is not affect the interest of the public at large. According to the IA is allowed, the parties are permitted to compound the offence. Consequently, the criminal proceedings allowed, the FIR and the complaint in crime number 170/21 by Sirah Police pending on the file of which court? Principal Civil Judge, Senior Division, CJM, Sirah, District Tumkur is hereby caused. Sign module. All parties should sign it along with the councils. Okay, next to 49, Pratik.
49, Pratik AC.
Yes, sir. What is the case? Here for dispensation of production of the order. What is that order? So what is it? What is that order? Your bail has been cancelled by the session judge. Page number 19. What is the offense, sir? Murder case. Page number 19. Who was granted bail? Magistrate or session judge? Case is before the session judge now. Who is this accused? Sole accused. Sole accused. 302. Sole accused. Yes. Bail has been granted. Pradeep. Twenty-one. Where is the order of cancellation? 22. Which date? Accused, absent, advocate, submitted, he has given NOC to the accused, but no retirement memo has been filed with the court. On behalf of the accused in force. Medium not interested in representing the case. Under the law, 10 or Last date of also they are present. What is wrong? Witness, so many witnesses present. Last date also he was absent. On that day. Accused counsel, accused first time, counsel not there. All witnesses sent back and say next date, all witnesses present, accused absent. Counsel is not filed application for exemption. Then what to do? No question of giving opportunities. Take the bond 45 and 46. Where is the procedure for issuing notice, cancelling bail? Sir, why you remained absent? I will instructed your counsel. You know very well witnesses are present on the earlier occasion. Your lawyer absent. Purposely to avoid the recording evidence, you remained absent. Your advocate want to file no objection, NOC, stating you do not want to cross-examine the witness. Exemption also not filed. Then you need a notice for you for cancelling. Take out that 45, form number 45, what it says. If you're absent, goes. Automatically. CRPC 45 form. Barcode bond. Nimge notice talk kodbekante elli barkondidvi. So, if you remain absent, gone. Sir, 21-6 he was absent. 21-6 he was absent. 26-6. Then his absent is absent. No question of issuing, sir. If you ask bail, definitely will consider. If you challenge, definitely will not get anything. Yes. Where is the law? Where is the law laid down? No law is laid down. Take another judgment. Sir. Show the law, sir. I am in 56 only. So any law laid down in this regard, taking out the bond, surety, everything. Herbal courts definitely will issue no one NBW. They call. You know very well when witnesses are there, they're going to support the prosecution case. Purposely avoided your advocate. Second date, you avoided. He filed the NOC. This is all drama. It will not entertain. Communication with the advocate, this advocate without not taking NOC not a party, he failed by not NOC. In fact, the trial court did not accept the NOC. No question of granting bail to you. If you ask bail, file bail petition before the court, it will come before the appropriate roster bench. They will grant bail or rejecting bail. You can't challenge that order is not correct. I don't find any other. I will write law on that point. I just get the number on that point. Since unless you are after the cannot be cancelled. Not 70 supposed to become student, otherwise not I would have filed an application for cancellation. You could say when witness is there, you file absent. Your advocate was there, you has not filed application. Where is the take in the cancellation of bail? ನಿಮಗೆ 70 class 2 ಫಸ್ಟ್ ಕೊಡಬೇಕಂತ ನೀವು 40 class 45 ಫಾರ್ಮ್ ನಂಬರ್ ಇಸ್ ಮೆನ್ಷನ್ ದೇರ್ ಏನು ಬಾಂಡ್ CRPC is their form but undertaken to appear what it says. I don't anything. You can't release on bail. If you want file bail application, get the bail. 2 ವರ್ಷ ಆಗಿದೆ, get the bail. Witness examination ಆಗ್ತಾ ಇದೆಯಾ? What is the next stage? See, challenging that order is very easy. But what is the law on that point? ಎಲ್ಲಾದ್ರೂ ಲಾ ಲೇಡನ್ ಮಾಡ್ಲಿ ಅದರಲ್ಲಿ ನಾವು ಅಲೋ ಮಾಡ್ತೀನಿ ಫಾಲೋ ಮಾಡ್ತೀನಿ ಲಾ ಲೇಡನ್ ಸರ್ ಗೋ ಟು ದಿ ರೋಸ್ಟೆಡ್ ಬೆಂಚ್ 439 ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ನಾವು ಕೊಟ್ಟಿಲ್ವಾ ಒಳಗಡೆ ಇದ್ದಿದ್ದು ಕ್ಯಾನ್ಸಲೇಷನ್ ಅಲ್ಲ ಯು ಫೈಲ್ ಅ ನೆಸರಿ ಅಪ್ಲಿಕೇಶನ್ ನೋ ಕ್ವೆಶ್ಚನ್ ಆಫ್ ಚಾಲೆಂಜ್ at the request of petition counsel case is adjourned for a week. Yes sir. What is the next date? Next date? If it is not date, we will issue direction to conclude the trial early. Yes, sir.
R.V. Shivanand Reddy, correspondent.
Yes. Nelaturga. What is IF for suspense of sentence and bail? Revision. Revision. You have a petition.
Appearing for petitioner, my lord.
Hello. This is a revision.
Out, my lord.
Why revision came before me? Earlier, that order over. Now I am not sitting on that roster. If that order to be recalled or modified, it's all right. If you want to file fresh application, you have to go before the roster bench, sir. If my order want to be modified or extension of time, then we will consider. Otherwise, where is my order? Earlier order. Said in the IA, who is Byros advocate. Sir, petitioner counsel.
Yes, sir. Yes, my lord.
What is your prayer, sir? Don't waste the time of the court.
My lord, ಆಗ್ಲೇ ಇದು ಕನ್ವರ್ಜೆಂಟ್ ಇದಿದು CC ನಂಬರ್ 2412 ಅಲ್ಲಿ ಏನ್ ಹೇಳಿದ್ದಾರೆ ಅಂದ್ರೆ ಸೆಟಲ್ಮೆಂಟ್ ಆಗತ್ತೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಸೊ ಹಂಗಾಗಿ ನಮ್ಮ ಪ್ರೇಯರ್ ಏನು ಅಂದ್ರೆ ಒನ್ ವೀಕ್ ಟೈಮ್ ಕೊಟ್ರೆ 25% ಅಮೌಂಟ್ ಡೆಪಾಸಿಟ್ ಮಾಡ್ತೀವಿ. ಇದು ಸಸ್ಪೆನ್ಷನ್ ಆಫ್ ಸೆಂಟೆನ್ಸ್ ಆದ್ಮೇಲೆ ಇನ್ 1 ಮಂತ್ ಒಳಗಡೆ ನೆಕ್ಸ್ಟ್ 25% ನ ಡೆಪಾಸಿಟ್ ಮಾಡ್ತೀವಿ my lord.
So earlier, no question of suspending sentence by this court. This is first time coming.
My lord, ಅವಾಗ ಏನಾಗಿತ್ತು ಅಂದ್ರೆ ಕೋವಿಡ್ ಬಂದಿದ್ರಿಂದ ಅವ್ರ ಹಸ್ಬೆಂಡ್ಗೆ ಹುಷಾರಿರಲಿಲ್ಲ my lord. ಅವ್ರು ಅಡ್ಮಿಟ್ ಆಗಿದ್ರು. ಮೆಡಿಕಲ್ ರೆಕಾರ್ಡ್ಸ್ ನ ಸಬ್ಮಿಟ್ ಮಾಡ್ತಿರ್ಬೇಕಿದ್ರೆ
ಅದಕ್ಕೆ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಫ್ ಟೈಮ್ ಕೇಳಿ. Suspension of sentence collect ಬರೋದಿಲ್ಲ. You have filed application as good as is a fresh matter for suspending the sentence. That is not permissible. This court already passed the order on 23/7/21.
Yes, my lord.
Again, once again, no question of suspending sentence, same sentence, second time. If time is expired, seek extension of time. That is the law.
Yes, my lord.
Study there, show the DD, check everything. 50% amount ordered by this court.
Yes, my lord.
Ready?
My lord, ಅದೇ 25% 1 week ಅಲ್ಲಿ ಮಾಡ್ತೀವಿ my lord.
IA filed by the petitioner, IA 1/25 petition for suspension of sentence and granting the petition for suspension and for bail. The respondent counsel brought to the notice of this court. This court already suspended the sentence and enlarged the petitioner and bail by imposing certain conditions by the order dated 23/7/2021. Suspending the case, question of suspending once again by filing similar application is not survived. Hence, not sustainable. Hence, IA 1/22 is dismissed. Second time suspend madak barala. I am not a regular roster batch. You can ask extension of time. You consider definitely. And you can't reduce to 25%, which already 50% order is there.
Yes, madam.
You are not showing charge to the court, sir. You have to deposit the amount. In spite of 6 months, you are not able to deposit.
ಪ್ರಾಬ್ಲಮ್ ಇದ್ರಿಂದ ಅಷ್ಟೇ
ಅದಕ್ಕೆ ಮಾಡಿಫಿಕೇಶನ್ ಕೇಳಬೇಕು. You can't file fresh application for suspending sentence. You can't suppress the material fact before the court. Yes. Jayasimha. Yes, what is the case, sir?
Police filed a charge sheet against this petitioner. Offense 92. Well, KPI. Petition number 1 is advocate. Petition number 2 is lecturer.
Practicing advocate or?
Both are brothers. So the allegation is 96 old offense
92.
sorry 90
Nuisance. Nuisance. Nuisance case ರೀ.
Yes, my lord. So they are abusing
ಹೋಗಿ ₹100 ಫೈನ್ ಕಟ್ಟಿ. ₹100 ಫೈನ್ ಕಟ್ಟಿ.
imagine reality. So according to section
Where is it?
section statute column number 6 and 7 not valid. So it is imagine there is no records. The petition number 1 is
Where is the complaint of the police?
complaint is page number 18 my lord. Page number 18.
Sikara police station. Ranjit Kumar ಅದು ನಾನು
Try 9 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ಪ್ರಾಣ
ಶಕ್ತಿಗಳಿಂದ
ಸಾರ್ವಜನಿಕ ಪ್ರಸ್ಕರಿಗಳು ಅಸಮಿಗಳು ಒಪ್ಪಂದಗಳು ಸುಳ್ಳು ಮಕ್ಕಳ ಬೋಳಿ ಮಕ್ಕಳ ಅಂತ ಇತ್ಯಾದಿ ವಿಷಯಗಳಿಂದ ಬಳಿಕ ಸಾರ್ವಜನಿಕ ಶಾಂತಿಯಿಂದ ಬಗ್ಗೆ ಭಂಗವನ್ನ ಉಂಟು ಮಾಡುವಂತೆ ವರ್ತಿಸಿದ್ದನ್ನು ನಾನು ಸದರಿ ಅಸಮಿಗೆ ಸಾರ್ವಜನಿಕರಿಗೆ ತೊಂದರೆ ಉಂಟಾಗದಂತೆ ಬೈದುಕೊಳ್ಳದಂತೆ ವರ್ತಿಸಿ
ಇವರಿಬ್ರು ಜಗಳ ಆಡ್ಕೊಂಡ್ರ ಇಲ್ಲ ಇಬ್ರಿಬ್ರು ಯಾರ ಮೇಲೆ ಜಗಳ ಆಡ್ತಿದ್ರ?
ಇಲ್ಲ ಇಬ್ರು
ಇವರಿಬ್ರು
ಬೈಕೊಂಡ್ರು ಅಂತ ಇಟ್ ಈಸ್ ಇಂಟೆನ್ಷನಲಿ ಫೈಲ್ಡ್ ಫಾಲ್ಸ್ ಕೇಸ್.
ಇಬ್ರು ಬೈಕೊಂಡ್ರ ಅಂತ ತಾನೆ?
ಬೈಕೊಂಡ್ರು ಅಂತ ಈಚ್ ಅದರ್ ಬೇರೆ ಯಾರು ಬೈದಿಲ್ಲ.
ಬೇಕಾಗಿಲ್ಲ, ಇಬ್ರು ಬೈಕೊಂಡ್ರೆ ಅದು ಗಲಾಟನೆ.
Panchayati is not coming into the limits of this petitioners my lordship. That is a different panchayat. ಅಲ್ಲಿ 15 ಕಿಲೋಮೀಟರ್ ದೂರ ಇದೆ. ಮೂರು ಪಂಚಾಯತಿ 3 ಕಿಲೋಮೀಟರ್ ದೂರದಲ್ಲಿದೆ.
ಸ್ವಲ್ಪ ಓದ್ತೀರಾ? ಅದಕ್ಕೆ ಸಂಬಂಧ ಇಲ್ಲ ಸರ್. ಈಗ ನೀವು ಇಲ್ಲಿ ಹೊರಗಡೆ ನಿಂತ್ಕೊಂಡು ಕೂಗಾಡ್ತಿದ್ರಿ ಇಬ್ರು, ದಟ್ ಅಟ್ರಾಕ್ಟ್ಸ್ ಓಲ್ಡರ್. ನಾಟ್ ರಿಕ್ವೈರ್ಡ್ ಟು ಸೇ ಸಮಥಿಂಗ್. ಈ ರೋಡಲ್ಲಿ ನಿಂತ್ಕೊಂಡು ಇಬ್ರು ಕೂಗಾಡ್ತಿದ್ರೆ ದಟ್ ಅಟ್ರಾಕ್ಟ್ಸ್ ಓಲ್ಡರ್. ಏನ್ರಿ HCGP ಯಾರಿಗೂ ತೊಂದರೆ ಇಲ್ಲ. ಇಬ್ರು ಜಗಳ ಆಡ್ಕೊಳ್ತೀರ, ಕೆಟ್ಟ ಕೆಟ್ಟ ಬಾಬಾ ಶಬ್ದಗಳು ಬೈದ್ಕೊಂಡ್ರೆ ದಟ್ ಇಟ್ಸ್ ಓಲ್ಡರ್ ಓನ್ಲಿ. O ಒಂದಿದೆ, R ಒಂದಿದೆ, ಎರಡು ಪ್ರಾವಿಷನ್ ಅಷ್ಟೇ ಇದೆ. ಅದು 40%. ಅವನ ಹೆಸರು ಅದಕ್ಕೆ ಮ್ಯಾಸ್ಟರ್ ಕೊಟ್ಟು ನೋಡಿದೀವಿ ಇದೆಲ್ಲ ಕರ್ಕೊಂಡ್ ಬರೋದು. ಅಲ್ಲಿ ಅಪ್ಪ ಆಯ್ತಾ, ಎಸ್ ₹50 ಕೆಲಸ, ಇದಕ್ಕೆ 50, ಅದಕ್ಕೆ 50. ಪ್ರೆಸ್ಟೀಜ್ ಇಶ್ಯೂ. ಇಬ್ರು ಜಗಳ ಆಡ್ಕೊಂಡು they both are came together for smashing down. What imaginary required, sir? This police officer, what grudge against you for filing a false complaint against an advocate?
Constable is given the report. Before the SHO is felt as the charge sheet against this.
That is how the case comes.
Column number 6 of the charge sheet and the column number 7 of the charge sheet not there.
What is column number 6? Read. Not readable condition.
Page number 15.
Yes. Page number
Column
15.
number 6 of the charge sheet is a name and address of the witness. PC number 14. Ranjit. Ajit Kumar, Arsikere police station, Pavda Taluk. So allegation is this column number 7. The very important, my lordship, the column number 6, there is no other independent witness. At least as per the allegations, there is no independent witness. There is no other witness.
How many witnesses?
One single, that is the only complaint. Serial one is the only witness.
If you go for without helmet, they charge for that. Where is the witness? Everything comes. So petty offenses.
So single witness. There is no document. At least.
What is the necessity for the police to file a false complaint against you both?
As per the column number 7 of the charge, they are not come to this panchayat office. Arsikere police ಠಾಣೆಯ ಮುಂದಿನ ಗ್ರಾಮದ ಪಂಚಾಯಿತಿಯ ಮುಂಭಾಗದ ಸಾರ್ವಜನಿಕ ರಸ್ತೆಯಲ್ಲಿ ಈ ಲಘು ದೋಷಾರೋಪಣಾ ಪಟ್ಟಿ ಅಂಕಣ 4ರಲ್ಲಿ ಇರುವ ಆರೋಪಿಗಳು ಸಾರ್ವಜನಿಕ ಸ್ಥಳದಲ್ಲಿ ಅವೇತ ಶಬ್ದಗಳಿಂದ ಒಬ್ಬರಿಗೊಬ್ಬರು ಬೈದು ಸಾರ್ವಜನಿಕ
KPR. What is your grounds?
This grounds is the respondent placed by the false charge sheet.
Yes, this is a regular grievance.
Without any document, my lordship.
What document required, sir?
CW1 is the only witness. Column number 6 and 7 is not valid, my lordship.
Who registered the case?
The imaginary complaint, my
Who
lordship.
registered the case?
He is saying to register the case. My lordship.
He has not made us witness.
No witness. CW1 is the only witness.
Whether both of them taken to custody at the time or they are not taken, just they should charge it. CGP takes note for notice for the state. ಏನು ಇದ್ರಲ್ಲಿ ಮಾಡ್ಬೇಕ್ರಿ this the CGP had to take instruction from the place. In meanwhile, there shall be interim stay of the further proceedings in CC number 274/16. Pending and file of JMFC at Pavagada. Date 1/24 or 24. See, I have seen a lot of older case. ಅದು ಯಾರಿಗೂ ಫಿಟ್ನೆಸ್ ಬೇಕಲ್ಲ ಕೇಳ್ಕೊಂಡು ಹೋಗಿ ಹಾಕೋದೇ ಕೇಸ್ ಅದು ಮ್ಯಾಕ್ಸಿಮಮ್ 100 rupees ಫೈನ್. ಎಸ್ ಸರ್. Yes, Sham.
Against the board member, saying that there is some misuse of the police, the article matter, the police cannot be mismanagement of funds, etc. In the church, it is purely about it is the church or any matter that was pertaining to internal administration of the church has to be investigated by the church administration only.
Who is the complainant?
The complainant may not be the district member of the church, may not be writing our next church, the C page number 25. Page number 26, the last one.
What is the date of the complaint?
The date of the complaint was subsequently this dismissal. The date of the complaint was
1710.
17/10/2021.
What is the date of dismissal?
The date of dismissal of this member is on 31st January 2020.
31st January.
2020.
After 10 months.
After 10 months, my lord, he is the one, my lord, who is intervening in all the
2020.
Yes, 2020 he was dismissed.
Complaint is 20.
Complaint, my lord, is filed on the 15th of Jan 2021.
More than yeah. 2020 is dismissed. January 20. Complaint is October 21. 2 years almost.
2 years almost.
Hmm.
Police cannot
What he says against you?
against the board members of the church, you would say that the board members of the church have received some funds. They were saying that the church development part of the church, all those.
Why he has been dismissed by the church?
Because of anti-church activities and anti-organizational activities.
What is prayer here?
They are not to find the because the police cannot investigate the accounts matters of the church. Essentially, investigated the internal administration of the church. And in that internal administration of the church investigated and found nothing. After that, he filed a complaint.
Where is found nothing? Where is the document?
The document where the church has already investigated and offended. Any may not have annexed E.
Page number
Page number 29.
29.
All the complaints were made to the bishop of Karnataka Central Diocese CSI. By my lord, the petitioner saying that all these matters is not basic unwanted not objection.
E 29 doctor.
Yes.
Who is this All Saints Church?
All Saints Church, my lord, is one of my lord well-known church, my lord, under the CSI.
They conducted the inquiry.
They have conducted the inquiry, my lord, they have said that this matter is already been taken into account. And my lord, I have produced, to be my lord there, I have produced, my lord, all the accounts, every document, my lord, and which the church main administration approved, my lord, every, my lord, expenditure.
No, no.
Besides, my lord, this complaint alleges,
Where the continuation of page number 30? So page number 29 is annexure E. Start from page number 29. Next page 30. I think it is not complete. Somewhere stopped in between. What is the finding of this inquiry authority?
the inquiry authority, my lord, simply say, this is taken into account, but my lord, all the church,
You know,
my lord,
what is taken into account? Whether they have found any mismanagement or not?
absolutely not.
Where is that finding, sir?
I will take your notice to that. I think just bear with me. Page number 45 onwards.
45. Yes.
Onwards, you will not retried. Number 45 or not, is the detailed representation that this was we are there earlier compared to church management. The church management should not consider all this.
I will just for the petitioner. Achieve take notice for the organ. Pending consider admission, I is allowed the further investigation against this petitioner. Because number 1 now, number 1 is here by state till next in crime number so. Issue notice to R2. Yes, sir. Yes. Who is the petitioner? Is accused facing the trial? What happened? 376 on POXO. Three. Who? Where is your application? DNA test? Where is the imputed honor? 33. Already before this court, you approached. Yes. You have filed application under section 45 there. That was dismissed. You challenged before this court. This court also dismissed it. Appropriate application. What application you have filed?
That came to dismiss I felt by the relationship by observing that there is no direction as such by any court.
Where is that impugned order? 30? Impugned order of the session judge, I must.
Please.
Is page number 8? Alleged victim girl and her daughter. Where is the FIR and complaint? Were not produced. What is the fact of the case?
Both of them planted now.
17 years, huh? Sorry.
Then they used to have the out of that she gave birth to change. The issue of the problem the fraternity of the same.
She has given evidence before the session judge.
Yes.
Where is the evidence?
The evidence is not present. Because I have only the order.
Correct. See, whether the accused's father or not is not a material issue before the session judge. Whether he has committed rape or not. That is the issue before the court. Is it not? Whether if she supports he has committed rape, if she says yes, ravished, the birth of the become a pregnant child are together different. Even if a married woman is raped, it's a rape. No question of whether the child born to him or not is immaterial to the court. Whether the offense is committed or not. Whether the prosecution is able to prove that he has committed the offense of rape. These are subsequent event becoming pregnant and delivering the child. What opportunity, sir? Statement is recorded. Statement is recorded. Statement of 313 is recorded.
Yes.
There is your statement.
Accused it.
313 statement.
Yes. That is not produced.
When you accuse
Not
Nanjunda Gaudre, when you will get opportunity of defense evidence after 313 statement, then
in the matter of only I meant
no sir, no sir. You can't examine any witness prior to completion of the trial and 313 statement. If you want to take defense in 313 CRPC, then you have to prove.
I accept it. I accept
Then,
it. Say I accept it.
sir,
Question.
whether child is belong to this accused or not is not the issue before the court. Whether he has committed rape or not. That is the issue.
They are the father
Be-
or mother. That is also not.
ಬೇಕಾಗಿಲ್ಲ ಅವ್ನ ಫಾದರೇ ಬೇಡ.
Again, the child is got out of that of the.
Not necessary, sir. That is not law of the land, sir. Whether the intercourse has occurred without consent and against the will of the victim. If she has given consent, if consent is given by a minor, it is immaterial, then become rape. That is the law. There is the question of thereafter becoming pregnant, child, paternity. We are not on the maintenance claiming paternity. This is not the court.
My elder brother. Yes, the problem is that I did that. But my defense is that no, I am not the prosecutor. Therefore, an opportunity has been given to me.
The case of the prosecution is not you are the father of the victim or a deceased child, the victim's child. Allegation is you are committed rape on her. Take charge. So these are not subsequent events, sir. Think you are not the father. If she says she has committed rape in the evidence,
But whether that is ultimately.
believing or evidence, disbelieving or evidence, appreciation of evidence by the session judge
Yes.
on the merit.
Yes. Yes. Now I am my elder brother is only kindly give an opportunity for me to report the case and also establish whether the case of prosecution is right.
Sir,
Opportunity has been
whatever maybe your opportunity starts after 313 CRPC. Defense starts after only.
true, ma'am.
Then
I accept it. Then only again, one prior to.
see, earlier bench not stated what application you should file. He said appropriate application, appropriate time.
This the evidence that the prosecution is completed. Subsequent to that, the matter of question.
Sir, your defense starts only after 313 CRPC.
True.
Prior to that, you have no right to have the
Not our evidence. And the evidence.
prosecution evidence complete aitalla. Where is the order sheet? Produced. You are stalling the trial for last 2 years, last 2-3 years.
That is there.
ತಗೊಳ್ಳಿ ಕಂಪ್ಲೇಂಟ್ ತಗೊಳ್ಳಿ, read the complaint without naming the witness. ಅದು ಇದು ಸ್ಟಾಪ್ ಮಾಡಕ್ಕಾಗ್ತದೆ. Stop it. Stop ಮಾಡಿ. Or complaint. Or complaint. ಅದೆಲ್ಲ ಜಂಪ್ ಮಾಡಿ ಪರವಾಗಿಲ್ಲ. ಇವ್ನು ಎಲ್ಲಿಂದ ಪರಿಚಯ ಆಗ್ತಾನೆ ಮಾತನಾಡಬೇಕಾದ್ರೆ ಎವಿಡೆನ್ಸ್ ಕೊಡ್ಬೇಕು. ನೋ ಒನ್ಸ್ ಎವಿಡೆನ್ಸ್ ಇಸ್ ಕಮೆನ್ಸ್ಡ್, ನೋಡ್ರೆ ಯು ಆರ್ ಆಲ್ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಇನ್ ಕ್ರಿಮಿನಲ್ ಸೈಡ್. ದಯವಿಟ್ಟು ಇಂಥದ್ದೆಲ್ಲ ತಗೊಂಡ್ಬಂದು ನಮ್ಮ ಕಡೆ ಒಂದು ಡಿಸಿಷನ್ ತಕೊಂಡು ಹೋಗ್ಬೇಡಿ. ಆಯ್ತಲ್ಲ. ಸಿ ಚೈಲ್ಡ್ ವೆದರ್ ಈಸ್ ಅ ಫಾದರ್ ಆರ್ ನಾಟ್ ಇಸ್ immaterial. Whether the intercourse took place against her will with her consent. If you take the contention is with consent, with will, she is a minor. Or consent is immediate, that is the law. ನಾವು ಏನ್ ಮಾಡ್ಲಿ? ಏನೋ ನೀವು ಅದು ಮೊದಲ ಬಂದಿದ್ದೆ, ನಾನು ಅಲ್ಲಿ ಸೆಕೆಂಡ್ ಟೈಮ್ ಹಾಕ್ಲಿಕ್ಕೆ ಚಾನ್ಸ್ ಕೊಡ್ತಿದ್ದಿಲ್ಲ. ನಾನು ಕರೆಕ್ಟಾಗಿ ಬರೆದು ಬಿಡ್ತಿದ್ದೆ. ಸರ್ ಆಲ್ ಡಿಫೆಂಡ್ ಸರ್, ಯು ಟೇಕ್ ಕಂಟೆನ್ಷನ್. ಸರ್ ನೀವು ಕ್ರಾಸ್ ಎಕ್ಸಾಮ್ ಮಾಡೋದು ಜಡ್ಜೆ ಕಳಿಸ್ಬಿಡ್ಬೇಕು ಇದನ್ನ. ಯಪ್ಪ ಹೋಗ್ಲಿ ಇದಂತ ಆ ತರ ಕ್ರಾಸ್ ಎಕ್ಸಾಮ್ ಮಾಡ್ಬೇಕು. ಆರ್ಟ್ ಆಫ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಟು ಬ್ರಿಂಗ್ ದಿ doubt in the mind of the court, to refer the matter to the handwriting expert or DNA expert. ಅದು ನೀವು ಎಲ್ಲ ನೀವು ಡಿಫೆನ್ಸ್ ಈಗಲೇ ಡಿಸ್ಕ್ಲೋಸ್ ಮಾಡಿದ್ರೆ, ನೀವು ಮಗು ಇಲ್ಲ ಅನ್ನೋದು ಇಮ್ಮೆಟೀರಿಯಲ್ ಸರ್. ತೋರಿಸಿ IPC ಅಲ್ಲಿ 375 ನಲ್ಲಿ ಆರ್ ಪೋಕ್ಸೋದಲ್ಲಿ ಮಗು ಆದ್ರೆ ಮಾತ್ರ 376 ಬರ್ತದೆ, ಇಲ್ಲ ಅಂದ್ರೆ ಇಲ್ಲ ಅಂತ. ದೆನ್ ಐ ವಿಲ್ ಅಕ್ಸೆಪ್ಟ್. ಇಸ್ ಇಮ್ಮೆಟ್ ಸರ್. ಸಬ್ಸ್ಕ್ವೆಂಟ್ ಈವೆಂಟ್ becoming pregnant and birth of the child, it is inevitable.
That is my problem.
ಯಾವುದು?
When there is 125.
ಅದ್ರಲ್ಲಿ ನೀವು ಹೋಗಿ ನಾನು ಅಪ್ಪನೇ ಅಲ್ಲ ಅಂತ ಹೇಳಿ, ಅದ್ರ ಬೇರೆ ಅಲ್ಲಿ paternity is important for granting maintenance. That is in rape the ಗೌಡ್ರೆ ಯಾಕೆ ಇದೆಲ್ಲ ನೀವು ತಗೊಂಡ್ಬರ್ತೀರಿ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಆಗಿದ್ದು? ನಮ್ಗೆ ಐ ಡೋಂಟ್ ಥಿಂಕ್ ಇಟ್ ಹಸ್ ನೋ ಕೇಸ್ ಫಾರ್ ಯು. ನಿಮಗೆ ಟ್ರಯಲ್ ಸ್ಟಾಲ್ ಮಾಡಿ ಇಟ್ಟಿದ್ದೀರಿ, ಅದು 2 ವರ್ಷ ಮುಂದೆನೆ ಒಂದ್ಸಲ ಬಂದಿದ್ದೀರಿ, ಮತ್ತೆ 2 ವರ್ಷ ಬಿಟ್ಟು 3ನೇ ವರ್ಷ ಮತ್ತೆ ಬಂದಿದ್ದೀರಿ. ಲಿಟರಲಿ ಸ್ಟೇಯಿಂಗ್. ಮೊದಲೇ ನಮ್ದು SOP ಬಂದು ಕೊರೋನಾ ಬಂದು ಟ್ರಯಲ್ ನಡೀತಾ ಇಲ್ಲ ಸರ್. Conviction is different, acquittal is different. ಅವ್ರ ಮಗು ಇವಂದ ಅನ್ನೋದು ನಮಗೆ ಅದು ಇಮ್ಮೆಟೀರಿಯಲ್. ಸಿ ಸೇಸ್ Section 90 of IPC. ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆಯಲ್ಲ, ಈಗ ರೀಸೆಂಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಆಫ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ನಾನು ಮೊಬೈಲ್ ಫೋನ್ ಇಟ್ಕೊಂಡಿದ್ದೀನಿ. ರೀಸೆಂಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ದೇ ಸೇಮ್ ಪಾಯಿಂಟ್ ಕನ್ಸಿಡರ್. ನಾನು ಬೇಲ್ ಕಡೆ ಸಮ್ಟೈಮ್ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ದೆ ಫಾರ್ ಯುವರ್ ಇನ್ಫಾರ್ಮೇಶನ್. ಸುಮ್ಮನೆ ಅದು ಮಗು ಅವನದ ಇಲ್ವಾ ಅಂತ ತಿಳ್ಕೊಂಡು ನಾನು ಬೇಕಾದ್ರೆ ಬರೀತೀರಿ, ಒಂದು ಲಾ ಲೇಡ್ ಮಾಡ್ಬಿಡ್ತೀನಿ, ಈಸಿ ಆಗುತ್ತೆ ಎಲ್ಲ ಬೇರೆಯವ್ರಿಗೆ. ಚಾರ್ಜ್ ಈಸ್ ಫಾರ್ he has committed the rape ಅಂತಾನೆ. he is a father of the child ಅನ್ನೋದು ಇಲ್ಲ. that is immaterial to the court, ಸೆಷನ್ಸ್ ಕೋರ್ಟ್. ಬೇಕಾ ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಡ್ತೀನಿ, ನನಗೊಂದು ಒಳ್ಳೆ ಜಡ್ಜ್ಮೆಂಟ್ ಸಿಗುತ್ತೆ. ಅದರ್ ಗೈಡ್ಲೈನ್ಸ್ ವಿತ್ ದಿ ಅದರ್ ಕೋರ್ಟ್ಸ್. After arguing sometime, the learned counsel for seeking permission to withdraw the petition. Permission granted, petition dismissed. ಅವ್ರು ಏನ್ ರೈಟ್ ಇದೆ ಅದು ಕ್ಲೈಮ್ ಮಾಡಲಿ. ವಿ ಆರ್ ನಾಟ್ ಆನ್ ದಟ್ ಪಾಯಿಂಟ್. ಯಾವಾಗ ಕೇಳ್ಬೇಕಂತ ಒಂದಿದೆ ಅಲ್ಲ. ಯು ಕ್ಯಾನ್ ಟೇಕ್ ಡಿಫೆನ್ಸ್ ದಟ್ ಈಸ್ ನಾಟ್ ಫಾದರ್. ನೀವೊಂದು ಒಪ್ಕೊಳ್ಳೋದಂತ ತಯಾರಿಲ್ಲ, ಡಿನೈನೇ ಮಾಡ್ತೀರಿ ಅಲ್ವಾ? ಮಾಡ್ತೀರಿ. This application will be on record. Try ಮಾಡಿ ಬೇಡ ಅಂತಿಲ್ಲ. You should put a question that the judge should be embarrassed and he should send. But ಮಗು ಹುಟ್ಟೋದು is not a issue before the session judge. ಹಾಗಾದ್ರೆ ನನ್ಗೊಂದು ಚಾನ್ಸ್ ಕೊಡಿ, ನಾನು ಜಡ್ಜ್ಮೆಂಟ್ ಬರ್ದ್ಬಿಡ್ತೀನಿ. It will stop all other unnecessary application before the session judges. ನಾನು ಒಂದು ಸರಿಯಾಗಿ ಬರ್ದಿಟ್ಬಿಡ್ತೀನಿ. ಅಲ್ಲಲ್ಲ ಸರ್, ಮಗು ನಿಮ್ದು ಇಲ್ಲ ಅಂತ ಬಂತು, ಇರ್ಲಿ ಇಟ್ಕೊಳ್ಳಿ, ಇರ್ಲಿ. ಲೈವ್ ಹೋಗ್ತಾ ಇದೆಯಾ? ಮತ್ತೆ ಸ್ಟಾರ್ಟ್ ಮಾಡಿದೆ.
Suppose the court gives the final or refers the matter to the expert stage, there will be an impact on the mind of the chain of its work. That is the
Yes, a dispute has been drawn. The trial court speed up the trial. Trial court that would speed up the trial. Yes. Next case, other note, I will give a pass necessary judgment. Yes, what is the compounding offense? Compounding, huh? Very. Oh, whether the joining or not joining. Stop.
No.
The parties are appeared through VC, identified by the London councils. Yes. IA1 does not serve. IA1/22. IA1/20. Please. Yes, Bharat Kumar. Ready? Ready? Anybody there for compounding the offences? Compromise cases? 71 Latif and Pradeep. Pradeepa, Pratika. What happened? 498.
Father assaulted to the wife, and now the matrimonial dispute, the divorce petition was filed. The divorce petition is done to withdraw the complaint. The divorce was granted with the condition that to withdraw the
It's a joint petition.
joint.
What is happens here? 307. What did it? 307. This is the unwoody wound certificate. Who was assaulted actually? Husband assaulted wife. 26 also there. There's the wound certificate. Now that divorce granted. Where is the wound certificate? What's the self? Hey, number Lakilwa. It's all right, sir. Recent judgment ನೋಡಿದ್ರಾ 307 ಕ್ವಾಶ್ ಮಾಡಬಾರ್ದು ಅಂತ ಒಂದು ಬಂದಿದೆ 188 307 ಕಾಂಪ್ರಮೈಸ್ ಅದಕ್ಕೆ ನಾನು ಓನ್ ಸರ್ಟಿಫಿಕೇಟ್ ತೋರಿಸಿ ಸರ್ ವಾಟ್ ಇಸ್ ಇಂಜುರಿ ಎಲ್ಲಿ ಹೊಡೆದವನೆ ಸೋ ಮೆನಿ ಇಂಜುರೀಸ್ ಆಗ್ತದೆ which injury is grievous in nature? Pneumonia, pressure, dressing, superficial injury, hanging, overlying skin, left main torso, abdominal laceration wound, cut on the right hand on the multiple stab wound with sharp weapon. In what again? Patient 22-1 1982 discharge. You grievous injury in the which injury grievous? There are so many injuries. There are so many injuries you have stated. Whether all 7 injuries are grievous injuries because laceration is there, superficial injury is there, superficial injury also there. How the superficial injury become a serious grievous injury? Doctor should say this injury number zones are grievous in nature and zones are simple in nature. Verification ಮಾಡಬೇಕು. He just cannot say injuries are grievous in nature. And it is not 20 days. The stab under automatically what take a abdominal injury. Where is the parties? This Grievous petition copy. This. Memorandum of settlement. Three not 7 and 326. I don't know what to get. 307, 307, 326, 307. Intention is there. 307. It's a grievous injury, simple injury doesn't make any difference. 307 is 307. Special federal petition to swallow used under section 482 CRPC for quashing the criminal proceedings pending in the file of principal district and session judge in SC by Mangaluru in SC 137/19 for the offences punished under section 326 307 of IPC. During pendence of this petition, both parties have filed the application. Early the application. Section 320 of CRPC, along with the joint affidavit for having compound the offence and seeking permission to quash the criminal proceedings. The Learned Counsel for the petitioner produce the document and submits. The petitioner and respondent number 2 have compromised the matter before the mediation center in respect of the MC number 316/2019 before the principal judge family court Mangaluru, and one of the conditions that the respondent wife shall withdraw the criminal complaint filed against the petitioner. It is pending on the file of SC so and so in sessions court. In number of them. 55 3B SC 137/19 and the based upon the settlement memorandum of settlement made before the mediation center, which was accepted by the family court and granted decree of divorce. Divorce was paid by the parties before the family court. So the Learned Counsel submits in of the understanding between the parties, amicable settlement in the mediation center, and a decree has been obtained for divorce. The respondent number 2 is not interested in prosecuting the matter and ready for quashing the proceedings. The latter concept of that petition also produced the idu Ram Gopal case. Leonard Council also produced some judgment of the Supreme Court in Ram Gopal, another state of Madhya Pradesh, in criminal appeal 1488/2012. A similar case where the parties were compound the offence. Even in the 307 case, the court can cause the criminal proceedings. Yes. All the cases with 19. The Honorable Supreme Court was held at para 19 as follows. In the judgment of the Honorable Supreme Court, the application and also the judgment of the Honorable Supreme Court in Gyan Singh versus State of Punjab, and the parties are amicably settled the dispute. The court has no hurdle for accepting the compromise and quashing the criminal proceedings. Accordingly, the IAS allowed permitted the parties to compound the offence. Consequently, the criminal proceeding the petitioner in SC number 137/19 for the offences 326, 307 of IPC hereby quashed. Parties are appeared through VC. Torsi, LA of the party. They are identified by the London Council for the petitioner and respond number 2. Then copy it qualified. Yes, sir. ಯಾವುದು ಹೋಗ್ತಾ ಇದೆ? Okay. Open the file. At the request of last time, at the request of HGP, list this better next week. 17. Subramania. Number 59. Subramania. Petitioner counsel remained absent. Even on the last date of hearing on 7/2/2022. And this court observed that petition is pending from 2/3/2020, almost nearing 2 years. In spite of the case is pending for nearly 2 years, the petitioner counsel not pursue the matter. Hence, petition dismissed for non-prosecution. Yes. Yes. What is the case, sir? Is the case, sir? Victim age.
She got married in 2012. Then not a lot of divorce. Then the sister is victim. Relationship with the
Sister of the victim.
Apparent is the victim.
Sorry.
The sister of the victim.
Sorry.
Apparent is not a situation. Victim got married under person.
Yaro.
She's 15.
Sorry.
Then he was mentally not fit, her husband. She got a lot of divorce.
All right.
Then the speaker and the victim has developed
Around the world.
They had the rounds and have the actors.
What she says now? Cheating of marriage.
Allegations. Now she learned from it. That's the proof of this.
Up to 2.5 years.
When she came to know that this Christian was married, the
What is the date of incident according to her in the FIR?
1/2016 to 20th of May 2020.
So continuous affair. It takes notice for the state. the London Council for the petitioner on IA1. Now case is pending before the Sessions Court or charge sheet is filed. Pending consent petition, IA is allowed. The further proceeding in CC number 12805/20 on the file of 39th ACM Bangalore is hereby state till next time. She notice to R2.
This case I am for the number 2, my lord.
Yes.
My lord, last date of the matter hearing, the matter was heard by your lordship, and there was an offer was exchanged by both the petitioner as well as respondent number 2 counsel, my lord, to settle the matter in the mediation. Avaga ನಾವು 21 ಲಕ್ಷ ಅಂತ ಹೇಳಿದ್ವ ಸ್ವಾಮಿ. ಅವರು
What is the matter?
matter is a dowry harassment case, my lord. Along with there is a 307 also is there, my lord. Last question.
Settlement is going on.
Settlement ಅಂತ ಕಳ್ಸಿದ್ರು ಸ್ವಾಮಿ, mediation ಬರ್ತಾರೆ, ನಿಮ್ ಮುಂದೆನೆ ಅವ್ರು 20 ಲಕ್ಷ ಒಪ್ಕೊಂಡ್ರು. ಅಲ್ಲಿ mediation ಬಂದು ತಿರಾ again they started from again 5 lakhs ಕೊಡ್ತೀವಿ, 8 lakhs ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಸ್ವಾಮಿ. I am for the respondent number 2, my lord, for the complainant, de facto complainant.
What about mediation?
Failure ಆಗಿದೆ ಸ್ವಾಮಿ. Mediation has been failed because whatever he assured before this lordship, your lordship.
No, whether mediation failed only in the monetary benefit or any other reason?
No, my lordship, only on the monetary benefit, my lord.
498, right?
498 along with 307 also is there.
What is your submission, sir? For what purpose? Afternoon, I'm having full bench. Full bench is there. Thereafter, reference is there. Don't think it will reach again. At the request of the petitioner counsel, sir, if you want to settle the dispute, speak with the other side counsel, settle the matter, or you argue the matter, I will dispose the matter.
Yes, my
Why
lord.
keep pending the matter for 2 years unnecessarily?
Now the matter has been committed to Sessions Court, my lord.
What happened? Mediation report. Learned counsel submit, mediation failed. Hence, list this matter next week. Money settlement market is
Much of my lord.
ಯಾವುದು 61 ಇದು ಎಷ್ಟಿದೆ? Lot of matters. ಇದೊಂದು ತಕೊಳ್ಳಿ, 62 ತಕೊಳ್ಳಿ. Anybody is there? Chetan, what is the dispensation? Interim custody, yeah. Buffaloes. Who are you? Buffalo owner or you are slaughter? Any rival claimant is there? Get the instructions. Your police station. Because some people will come and ask this in a Dharma, Blue Cross like that, they're coming. Why you are the owner? Why you are carrying? Breeding purposes. Why you are not getting instructions, sir? Spending for last 2 years and all cattle will die tomorrow. Already 2 years is pending. Time I will take up afternoon. Otherwise, Leonard HGP to take get the instruction from the concerned IO and list this matter 18-2. How to dispose that matter? ಏನು ಬರ್ದಿಲ್ಲ. Instruct, let him take instruction. How many lives are still there? How many died? What is his objection? Who is taking care now? ಬೇಕಲ್ಲ. Otherwise they will take care.
Lordship, appearing for the petitioner, Lordship, kindly grant a date in next week, Lordship.
Last time also you obtained time, madam. At the request of petition, case adjourned for 2 weeks. Yes, Ravi Shankar.
Obliged.
Ravi Shankar, yeah. VP Patil, Jeevan Nirlagi. Office to delete name of Jeevan Nirlagi. Correspondent number 1. And so name of VP Patil. Petitioner counsel. Not present. Yes, case adjourned for 2 weeks. Sir Rajagopal Swami, Gopal Swami. It's a council. Not present. Is this matter of a week?
My lord,
Latif,
appearing, my lord,
who are you?
my lord, petitioner, my lord, serial number 67, my lord, for CR.
Oh.
My lord,
Yes, ready.
week's time, my lord, because senior
At the
is,
request of the petition council, case adjourned for 2 weeks.
my lord, interim order may be extended, my lord.
Entry part idea.
Yes, my lord.
Yes, 6 entry part extended. Urgent better. Yes, 70. Latif.
Much of this.
Latif. He was here. Here, why should the pass over? Entry matter, anything is there? ನೆಕ್ಸ್ಟ್ ತಗೊಂಡ ಇವತ್ತು 2-3 ಕೇಸ್ ನಿಮ್ದೇ ಆಗಿದೆ ಅಂದ್ರೆ ಎಷ್ಟು ಕೇಸ್ ಒಬ್ಬರದೇ ಮಾಡಿದೆ ಬೇರೆಯವ್ರಿಗೆಲ್ಲ ಅಪರ್ಚುನಿಟಿ ಬೇಕಲ್ಲ. ಇದು ಯಾವ್ದು 16 ಇಂಟರ್ಮೆಟ್ ಇಸ್ ದೇರ್. ಎಸ್ 72 ಶ್ರೀನಿವಾಸ.
In the police registered FIR 498, and the circular of PG and IG had to reject it without family counseling. That circular is available to Lordship on page 96.
Where is that circular page number?
Page number 996.
498 offense.
498.
Who is the petitioner?
Petitioner is the husband.
Page number 98.
96. 96.
Circular.
2002 ಫ್ಯಾಮಿಲಿ ಕೌನ್ಸಿಲಿಂಗ್ ಕಳಿಸಬೇಕು. ಸುಮ್ಮನೆ ಗಂಡ ಹಾಕಿಕೊಂಡು ಒಂದ್ ಮಾಡಕ್ಕಾದ್ರೂ ಟ್ರೈ ಮಾಡಬೇಕು. ಸುಮ್ಮನೆ FIR ಆಗ್ಬಿಟ್ಟು ಪೊಲೀಸ್ ಅವ್ರು ಕಳಿಸಿದ್ರೆ ಸಂಸಾರ ಒಂದಾಗೋದು ಹಾಳಾಗ್ಬಿಡುತ್ತೆ ಅಂತ ಒಂದು ಸರ್ಕ್ಯುಲರ್. But if your lordship were to come to para number 3, bottom of that, the committee further advocates that the professional and trained family counselors should do the counseling in the woman's cell so that frivolous cases are screened at the initial stage itself. In section 498 of IPC is involved in rare cases. The report of the counseling process may be submitted to the concerned TCP or equivalent rank officer.
On what basis? On what basis you issued such a circular?
Circular is issued based on the advisory measures that were taken by states in duties to curb the misuse of 498. That is in the subject of.
Where is the laws or statute for issuing this notice?
This is after the guidelines of the Supreme Court.
Which judgment? Which judgment? Produce Supreme Court judgment?
No. This is circular number CR 33 miscellaneous 3.
No. These circulars are no basis of law. On what capacity he has issued such circular? This is older one. Subsequent judgment, Supreme Court said no.
Based on the Rajya Sabha first part, the Honorable Committee on the Petitions of Rajya Sabha in its 140th report has inter alia recommended the following effective measures to be taken by the state governments to curb misuse of section 498 IPC. But
So Supreme Court judgment or any other judgment,
Rajya Sabha recommendation
that recommendation
ಮಾಡಬೇಡಿ ಅಂತ ಹೇಳಲ್ಲ ಮಾಡಿ ಫ್ಯಾಮಿಲಿ ಕೌನ್ಸಿಲಿಂಗ್ ಮಾಡಿ. there are women police stations, there are ಮಹಿಳಾ ಸಹಾಯ ಮಾಡಿ, there are ಪರಿಹಾಸ್ ಅಲ್ಲಿ ಕಳಿಸಿ. ಈ ಕೇಸಲ್ಲಿ ಏನಾಗಿದೆ, 6/9/2021 21 hours ಕಂಪ್ಲೇಂಟ್ ಬರುತ್ತೆ. 6/9/2021 21 hours ಗೆ opponent ರಿಲೀಸ್ ಮಾಡ್ತಾರೆ. That is the question of law.
No, sir, that is not law at all. Where is the question of law? That circular is not law. That circular is not law. Please show the document or certificate of Supreme Court. This circular is law. And High Court judgment Torsi. This circular is law. How it become law? If some recommendation placed before this Rajya Sabha or Lok Sabha, it will not become as law. Yes, sir. Issue notice on next week.
ಅಷ್ಟೇ ಮಾಡೋದು. ಈಗಾಗಲೇ 3 ಡೇಟ್ ಆಯ್ತು ನನಗೆ.
ಹೋಗಿ ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ.
ಫಸ್ಟ್ ಡೇಟ್ ಅಲ್ಲಿ the bench was handicapped to hear me because I am related to the bench. Second ಅಲ್ಲಿ 7ನೇ ತಾರೀಕು
I don't think you have case now. ಇಲ್ಲಾಂದ್ರೆ ಮಧ್ಯಾಹ್ನ ಬನ್ನಿ, ಟೈಮ್ ಇದ್ರೆ ತಕೊಳ್ತೀನಿ. Now 1:40. You can't precise me. That the circular is not a law. Bring Supreme Court judgment. It should not be registered. Offense is cognizable offense. No authority can prevent the police from raising the case. That is the law.
ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಏನಾದ್ರು ಮೆಟೀರಿಯಲ್ ಇರಬೇಕಲ್ಲ opponent ಗೆ.
ಅದು ಬೇಕಾದ್ರೆ ಮಾಡಿ. ಅದಕ್ಕೆ ನೀವು ಫ್ಯಾಕ್ಟ್ ಮೇಲೆ ಬನ್ನಿ, ಬಟ್ ನಾಟ್ ಆನ್ ಸರ್ಕ್ಯುಲರ್. That circular will not help you. That is diluted subsequent. ಏನಿದೆ ಮಧ್ಯಾಹ್ನ ಬರ್ತೀನಿ. 1:40 ಸಾರ್, ಅದು ಒಂದು half an hour ಇದೆ. ಅದ್ರಲ್ಲಿ I try to manage. ಮಧ್ಯಾಹ್ನ ಬರ್ತೀನಿ.
Make one submission, madam.
Court officer. Court officer. Court officer. Court officer, sir.